And if a title is issued covering property of public dominion, that's not a valid title. The government has property of two types: property of public dominion and patrimonial property. With respect to the patrimonial property, just like any other properties, just like ordinary private property, that can be the subject of contracts. Property of public dominion, as long as it remains such, is subject to the special rules we just mentioned. Cannot be subject matter of contracts, cannot be acquired by prescription, cannot be burdened with dispense, etc. Is it possible to convert properties of public dominion to patrimonial property? The answer, of course, is yes. It is possible. How can that be done? Will the mere fact that property of public dominion is no longer actually being used for public use, or is no longer actually being devoted to some public service, will that automatically convert the property into patrimonial property? The answer is no, it will not. There must be a formal declaration. In the case of national government property, there must be a formal declaration by the executive or legislative of such conversion. Otherwise, the property remains property of public dominion. With respect to property of political subdivisions, the conversion must, of course, be authorized by law. You have a very good example of the Roppongi cases involving the property of the Philippines located in Japan, which were given to us by way of reparation by the Japanese as part of the reparations agreement. Those properties were originally intended for the use of our embassy, but they were never used for that purpose. Okay? After a long period of time, there was an attempt to sell these properties. The Supreme Court said, the mere fact that these properties in Japan have not been actually used for their original purpose, which was supposed to be for embassy use, does not automatically convert these properties into patrimonial property. They remain part of the public domain and consequently not available for private appropriation or ownership until there is a formal declaration on the part of the government to withdraw it from being such. Abandonment, according to the court, cannot be inferred. An abandonment must be definite. on the part of local government entities, just like the state, their properties are again subdivided into properties for public use and patrimonial property. Again, for property to be considered for public use, it must be open indiscriminately to the public. Otherwise, it cannot be said to be property for public use. In some cases, however, the Supreme Court, in determining whether properties of a local government unit should be considered as public or patrimonial, in some cases, the Supreme Court has instead opted to apply the special laws governing municipal corporations. Thus, in the case of Zamboanga del Norte versus City of Zamboanga, the Supreme Court said, we cannot possibly decide this case strictly along the lines and parameters set by the Civil Code in determining what properties are public use and what are private property. This involved the creation of a new local government carved out of a former political unit. In that case, and in similar cases involving local governments, the Supreme Court instead considered the use of the property, whether it is for governmental purposes or not. As long as the property was used for governmental purposes, it was considered property for public use or property of the public property. Still on this point, in the absence of clear evidence as to the source of the funds used in acquiring the property, which is currently being held by a local government unit, the presumption is that the property, the land, came from the state. Okay? Salas versus Arencio and some other cases. So, if a local government unit is currently holding property, but there is no clear showing as to the source of the funds used to acquire that property or as to how it acquired that property, the presumption is that that property, that land, actually came from the state, and the local government unit is holding it merely in trust for the state for the benefit of the inhabitants of the locality. Okay. If that is so, those properties, of course, cannot be considered as patrimonial property. They will be considered public property, and the national legislature will be considered to have absolute control over these properties. in some cases decided by the Supreme Court, it has been made clear that local government units cannot enter into contracts, cannot even validly authorized by means of an ordinance, the awarding of contracts over certain streets in favor of private individuals for purposes of having a flea market there. As long as the street remains a street, it's for public use, and therefore it is beyond the power of the local government unit to deal with by means of contracts. In one case, a local government unit authorized that a certain street in the area be converted into a flea market. There was an ordinance authorizing that. The court said that cannot be. What is quite clear from these cases is that while even under the local government code, local government units are allowed to withdraw, okay, certain streets when no longer necessary, okay, withdraw from public use. They cannot, in a manner of speaking, have their cake and eat it too. In other words, without actually withdrawing the road from public use, they will still maintain it as a street and at the same time operate it as a flea market. That cannot be done. So, in these cases decided by the Supreme Court, sabi ng court, hindi pwede yan. Okay? As long as they have not been withdrawn from public use, they remain property for public use. And you cannot at the same time enter into contracts with private individuals who intend to operate a flea market in that road. Kailangan, kung gusto niyo i-withdraw, i-withdraw nyo. In other words, that street will cease to be a street. It will no longer be a street. Only after that can you deal with it as patrimonial property, but not while it is still a street. You recall the ruling of the Supreme Court in Chavez versus Peya. Okay? Of course, you know very well what this is all about. Huh? There was this agreement between the Public Estates Authority and the Amari. Amari would reclaim areas of Manila Bay, and as payment, it will be paid with reclaimed lands. Okay? So, you remember the ruling of the Supreme Court in this case? Maliwanag na maliwanag. Sabi ng Supreme Court, with respect to the reclaimed lands on Freedom Island, around 157 hectares, which are covered by titles in the name of the Public Estates Authority, they are alienable lands of the public domain.